Good morning. This is Marty with Speaking on Law, and we're here with John Bogart, attorney in Salt Lake City. Welcome back, John. It's good to see you again.
Thanks, Marty. It's nice to be back and talking with you again.
Well, I know a lot's happened in your world, and would like to catch up and see what's happening. I know we talked off camera a little bit about a recent case that you had with the Supreme Court. Can you tell us a little bit about that? I know there were two parts to it, and tell us what happened and what was kind of interesting to you.
Sure. The case is handed out at the end of last year, 2014, actually December 23 or 24th, something like that. And it's Utah Resources International versus Mark Technologies. And it's an important case, at least in Utah law. It's effectively a landmark case because it solved a couple of problems that had been hanging around in Utah law for a long time but hadn't been addressed. So the substance, the nature of the case had to do with share consolidation. You know, privately held companies or closely held companies, there are times when the company wants to reduce the number of shares and reduce the number of shareholders, and so you get what are called reverse stock splits. And our client, URI, did one of these things. And one of the things that happens when you do these sorts of reverse stock split share consolidation is folks with minority interests end up with partial shares, and they have to be bought out in some way or other. And there's a formal process for that that's the case in every state. It's roughly the same. The company comes to a valuation of the value of those shares, which is measured by the value of the ownership interest of the assets of the company, and makes an offer to the shareholders who either accept it or don't. And when the shareholder decides, they're called dissenters in this context, the dissenter is not happy with the price, there's a formal process by which they can resolve the dispute about what the actual value of the shares was or should be. And that's how this case got started. And the issue for Utah law is there aren't very many cases at all on how to do the valuation of shares in this context. It's just one of the things about being a smaller population state. There are often areas, very important areas economically and for the business world, which don't get litigated often enough to get up to the Supreme Court, the Court of Appeals, so you sometimes don't have clear directions from the court about how to do things that are crucial, in this instance, how to do a fair valuation of the shares of URI. And that's what we took up to the Supreme Court, and that's what we got a resolution on about really how that fair valuation is done and what the some key or important kinds of deductions on the value of the company that have to be taken in coming to a conclusion about what fair valuation is.
Well, I know when you talk about fair valuation and you talk about asset value, I know there's book value and market value. What were the 4 or 5 things that the court focused on?
Yeah, let me start with fair valuation, which is a little different than a fair market valuation. And I don't want to go into the details because that's what you hire lawyers for and spend hours in your own time. Fair valuation is different from fair market in the sense that the fair market, which is what you do when you try and appraise a house, for example, it's what people would buy the company for, or buy the shares in particular, because you're talking about valuing shares. And fair market valuation of shares isn't a very good thing for a minority holder because your shares aren't worth as much as they might otherwise be, merely in virtue of the fact that you have no control over the company and can be gotten rid of. And so that's not a fair way to price. Instead, what you get for the pricing of the shares is what's called fair valuation. And that excludes, effectively, certain kinds of fair market considerations, like the fact that you're a minority shareholder. And so fair valuation is what the company value looks like, and it's sort of as a first approximation. It's what it looks like to the majority shareholder, or should look like. And you do that in the normal ways, which is you get an appraiser to do sort of cash flow, income evaluations, asset evaluations, and so on. Now, what was of crucial interest for us, and which turned out to be important, and the area on which the court didn't really have any opinion stated clearly before, had to do with certain kinds of discounts that you want to normally take from the fair valuation number, so that you're being fair both to the center and to the remaining company shareholders. And the first one was for a company whose business is whose ordinary course of business involves sale of, say, real estate, there are significant transaction costs. As everybody knows, when you sell real estate, there are broker's fees and so on. Question is, what happens? How are those to be treated? Utah Supreme Court said there was a deduction you could normally take for this if it's an ordinary course of business for the company. Then those transaction costs are part of what are going to come out of the company no matter what, and it's not fair to push all of that onto the remaining shareholders. The second thing that the Supreme Court said was that what is called trapped-in capital, which is just capital gains tax that's going to be paid when something like real estate gets sold, that tax has to come out of the valuation dollar number as well, because once again, it's trying to allocate to everybody the benefit of the sale, which in doing that, making the sale, you're going to incur taxes, and those should be shared evenly and fairly. The third one that the Supreme Court noted was certain kinds of income tax also get deducted. And that would be, for example, royalty income on oil and gas. Because once again, in the court's view, roughly what's happening is that tax is going to get paid. It should be paid according and distributed as a cost to everybody who's involved in the company as a shareholder. So it's a deduction, a pro rata kind of a deduction, as these others are, to the dissenters, so that they're not taking, in effect, a windfall. And the final element for the court's decision in this case had to do with the fact that URI was in fact a minority shareholder in another entity. And so part of what the appraisals had to do was figure out what was the value of that minority interest in this other company. And what the court noted was that minority interests have a discount attached to them because of the fact that you're a minority and not in control of the company, and effectively at the mercy of those who are in control of the company. So the court held there was a deduction in the value of that minority interest that should be reflected. And the result was, for us, that a reversal of the trial court, and we'll be going back down there and sorting through these issues with a new judge, because the case has been reassigned.
Yeah, I can see that you've taken a pretty complex issue of fair valuation and broken it down into some components, and the court focused on those items. Were there anything else that you saw that was important to the Supreme Court in this case?
Yeah, there was actually one other very important thing that happened in the opinion. Now, the fair valuation thing is, of course, important to folks who get involved in cases where they have to value share consolidation and so on. So it might be seen as kind of narrow. Those factors are going to weigh out more broadly, but that is substantively a narrow thing. The other very important thing that came out of the Supreme Court decision had to do with something that's going to be important to anybody who wants to appeal a case, and they're the judgment debtor. The judgment debtor is just the person who lost in the trial court below and owes somebody else money, and there's a judgment against them. Under Utah law, up to now, it wasn't entirely clear, and I'll talk about that in a second, but it looked as though if you were a judgment debtor and you paid the judgment voluntarily, you couldn't appeal. Paying the judgment voluntarily extinguished your rights to appeal. Now, you might wonder why anyone would want to pay judgment when they have a case up to take up on appeal. And there are kinds of practical reasons which make it, in a number of instances or circumstances, fairly important to be able to make the voluntary payment. So, for example, if you don't do a voluntary payment, then the creditor, right, that's the person who's got the judgment, can go and garnish bank accounts, right? So they serve some legal papers on your bank, and they sweep money out of your bank accounts, and they can do that on their own schedule, not yours, which can cause a bunch of problems, especially for smaller companies or individuals who lose access to funds unexpectedly. It's certainly not good for credit, or if you're trying to expand your business and you need to work on some loans, and the bank may well be aware of the judgment, but having folks come in and taking money and stuff, that's not going to sit very well with the folks who provide you with money. Also, as part of the general process for getting involuntary payment, you can have your officers and employees hauled into court for an examination about company assets. And so you have to disclose information you may not want to disclose. And of course, it's very disruptive to be hauled around for these what amount to depositions on company assets or your personal assets. So those are very disruptive things. There's also, at least in a number of instances, a kind of reason that's outside of that kind of disruption, which is accumulation of interest. So in the kind of case that you or I was involved in, there's statutory prejudgment interest. And in Utah, the current statute provides for prejudgment interest, which is about 3 times the market rate, prime rate for interest. And so if you have a big judgment, excuse me, you want to get that cut off somehow. The way you cut it off is pay the judgment. So that's another kind of reason why you want to voluntarily pay it. As I said, under the old rule, a voluntary payment of the judgment extinguished your rights to appeal. So folks who were judgment debtors and trying to appeal cases either had to just bear with the disruptive effect of non-voluntary efforts to collect the judgment, or they had to gamble on paying parts of the judgment, then hope that that didn't affect the appeal right. And what we got the court to agree to and clarify the law was that a voluntary payment could, in fact, extinguish your right to appeal, but you could preserve it as a judgment debtor by making a clear, express statement that the voluntary payment was done without waiver of rights to appeal, that you were paying, but you were not waiving your appellate rights. So that's a big change, and that's a change that's fairly widespread in its importance across appellate practice. Excuse me. And that was the second big thing that came out, and I think probably that's the piece of the case will get known for more than the issue about fair valuation of a company, partly because we're more used to fair market valuations than fair valuations, and partly because that's a more specialized area. So those are the two big things that happened recently for the firm. We think it was a big success for the court.
Well, congratulations. I can see with the tendency of that part of the how that is a decision, and hats off to you for that, and I'm sure your clients are more than elated for the representation that you had there. On the other side, I know that Utah has come up with some new revisions to some rules, and do you have a minute you could share with us a little snippet of what that's about?
I'd be happy to. Utah underwent a very large, very significant revision of the rules of civil discovery back in November 2011. And it's still being worked through, and the committee still, and the court is still tweaking those changes. But what's interesting is they've started doing, one of the National Centers on Judicial Practices has been doing an empirical study on the effects of the rule changes, which, in very brief form, categorized cases according to tiers, so the amount of the dollar value of the claim was either tier 1, which is about $50,000 or less, or tier 2, which is 50 or 75, I've forgotten, up to 300 and 300,000 and above is tier 3. And doing the study is trying to find out what has happened in the way people are practicing, what are lawyers and parties doing in light of the changes. And the report's not final. I've had access to a draft. But some of the interesting things that are turning out is, one, for small dollar value cases, the rules have been very successful in moving the cases through and keeping costs moderated to the value of the judgments. A big success there. Surprising things in the studies thus far are that there appears to be very little change to cases which fall under tier 2 or tier 3 in terms of how long it takes them to be resolved, how much money is being spent on discovery, use of experts and the like. And one piece that I found close to astonishing is that it turns out a very large portion of tier 3 cases, right, cases with $300,000 at stake or more, are being resolved without any discovery at all. A much higher percentage than I would have thought for those things happening, because they're not being settled at the outset of the case, but they're going forward through the discovery period with little or no discovery actually happening and then being resolved, which was a kind of surprise to me. I'm not surprised by the findings thus far that a significant portion of lawyers in Tier 3 cases are just opting out of the discovery limitations. That's of some concern to the committee, I suppose, but it struck me as perfectly appropriate. The rules are well structured for those kinds of cases. But those are some interesting things that are happening, and the Civil Rules Committee will continue to change kind of how practice will work.
Well, I guess that is interesting. I guess the summary that I'm gathering from that is that as they're fine-tuning these rules and making these revisions, it's actually a step of progress towards mitigating cost and in relationship to the size, and that's good news for the consumer or the businessman on the street, right?
It is, and along that line, one of the proposed changes that the committee's thinking about, and they've actually started some pilot programs, is mandatory aggressive management of cases by judges, so that taking a more active role during the discovery process, where the judges will hold status conferences and set schedules and require lawyers to show up and talk to the judge about the status of the case, what kinds of issues are remaining, and what they think they're doing with respect to discovery. And part of the aim of that proposal and the test pilot projects is to try and keep Tier 3 cases, which are the big cases which are more likely to involve businesses than individuals, keep those under control so that costs don't just seep out around the edges of the rules and you're still back to a world where no one can really afford to litigate a case under $500,000 or $1 million. And that's something that's a bad development over the years. And so they're making some progress. I think that's good news for consumers who have generally lower value cases, and there's now ways they can get them resolved and with the help of lawyers successfully.
Yeah, that is interesting to note. I really appreciate that update. And John, as always, thanks for joining us this morning. Congratulations on the Supreme Court ruling in your favor and your clients. We always love to visit with you. And for those of you out there who need legal representation or think you do, it would be in your favor to reach out to John, and I'll put his phone number here on the screen. You can see 888-895-9517 is his number, directly to his office. And if you need the best there is, please contact John here in Salt Lake City, Utah. Again, John, thank you for your time this morning, and we'll talk to you again soon.
Thanks, Marty. It's been a pleasure.
You bet. Bye-bye.